The docket for Monday, January 31st, 2022 consists of one case. Appeal number 115964, State of Kansas versus Kyle, Trevor, Flack, Franklin County, death penalty case, briefs both sides. Your Honor, this case is scheduled for a 60-minute argument on each side. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the Court, Clayton Perkins of the Capitol Appellate Defender Office, appearing on behalf of the defendant appellant, Kyle Trevor Flack. I am joined today at counsel table with Caroline Zuschek of the Capitol Appellate Defender Office and Deborah Wilson of the Capitol Appeals and Conflicts Office, present and ready for argument.
May it please the Court, the State appears by Chris Elsleger, Deputy Solicitor General, and Natalie Chalmers, Assistant Solicitor General. Ready for argument.
Thank you, counsel. I think counsel is aware of the plan, but just so those watching have an idea of our time today, these arguments are set for a longer period of time than a typical argument before the court. We've allowed each side 60 minutes of argument. Our plan will be that we will have Mr. Flack's counsel argue, and at the conclusion of that opening argument, we will take a recess of 15 minutes and then conclude with Appellee's argument as well as any rebuttal time that Mr. Flack has reserved. Counsel?
Good morning, and may it please the Court. I am Clayton Perkins of the Capitol Appellate Defender Office, appearing on behalf of the defendant appellant Kyle Flack. I would like to request 10 minutes for rebuttal.
10 minutes is reserved. Thank you, Mr. Perkins.
This is a direct appeal from a capital murder conviction for which a sentence of death was imposed, as well as convictions of first-degree murder, second-degree murder, and being a felon in possession of a firearm, for which consecutive off-grid and on-grid sentences were imposed. I will be referring to victims by initials throughout my argument this morning as they may come up, consistent with the concerns behind Kansas Supreme Court Rule 7.043. And as way of a roadmap, I hope to touch upon at least issues 1, 2, and 5 in the appellant's brief this morning pertaining to the denials of continuances, the Miranda violation, and the use of the heinous, atrocious, and cruel aggravator in this case. I would start issue 1 with a point made by defense counsel at the hearing on the third continuance motion that preparing for trial during trial is a recipe for disaster. It is in that context where defense counsel told the court that it would be a miscarriage of justice to go forward with their lack of preparation, where defense counsel had not completed review of mountains of discovery or their fact investigation in a case where real questions of guilt or culpability exist regarding Mr. Flack and unidentified third parties, where defense counsel's motions practice had been stunted or almost entirely responsive, and where investigation and development of the mitigation phase evidence was severely incomplete. And it is in that context where the district court's denial of a continuance was a myopic insistence upon expeditiousness in the face of a justifiable request for delay, where the denial of the requested continuance upon the showing of good cause was unreasonable, and Mr. Flack's constitutional rights to present a defense were violated, along with his statutory rights to a reasonable time to prepare and continuances for good cause.
Counsel, let me ask you on that issue. What's the test that we use to decide that this is reversible error?
So there are several ways we've raised this issue, and I think several tests combined with those. We, of course, raise this as a denial of constitutional rights to due process and to present a defense tied to the Sixth Amendment in Sections 5 and Section 10 of the Kansas Constitution Bill of Rights, which there isn't, I don't think, a clear test to, but if, this court has at least said there is de novo review. There is also the statutory violation of KSA 223406, that a defendant shall be entitled to reasonable time to prepare for trial after arraignment, which we argue is a totality of the circumstances test. And then there's continuances for good cause, which are a abuse of discretion standard of review.
The problem that I've wrestled with on this one is, I mean, defense counsel comes in and says, I'm not ready. And the state says, well, you ought to be ready. You know, you've had years. So how do we decide that the district court made a mistake in how it ruled? We can't just say that defense counsel will tell us when they're ready and you get to go to trial. So what's the measuring stick here?
And I am going to orient my argument this morning around the good cause and that the denial of the continuance was unreasonable in this context, which is a rare circumstance, but is met in this case given the levels of, or the numerous issues that counsel had put on the record with preparation and investigation that were going on in this case. And
Are you suggesting then that good cause, a violation of that test would equate to a due process violation? Or is due process measured in some different way?
I think that due process should be measured in a different way, although I think there are overlapping elements to these different tests. Certainly when the good cause standard is met and the denial of the continuance is unreasonable, then that is going to, particularly when it's pertaining to defense counsel's preparation and investigation and lack of, and issues with witnesses, then that is raising to the level of due process violations, the denial of the right to present a defense.
Have any obligation to show us what would have been different if there had, in the trial, if there had been a continuance granted? For example, that you would have had this expert and this expert would have been able to do this, or any other measure, any other tangible thing that you can kind of point to? Is that required before we could find a due process violation?
I don't think it is inherently required, but we also have multiple hearings and proffers where we talk about our witnesses that were unavailable in this case. So that is present here. There were defense experts that were unavailable, particularly going ahead, you know, we had investigation issues where we did not have time to consult with a tire tread expert. And that is notable in this case because this is a case where there was tire tread evidence that did not match the car that the defendant was driving in this case at the location where LB's body was discovered, but that was something that defense had to give up looking into further. We did not have a digital forensic scientist to look at cell phone analysis because they had not at the time of trial finished their reports. And that is significant because this is a case where there was cell phone evidence that was significant and cell phone evidence that even went as far as to show that AS's phone was moving or was located at a cell phone tower near John Brown Road, which is near the dump site or the site where they found LB's body.
I know that you said that, I know you gave a list of those things to the trial court, but I guess my question would be, is there after the fact and necessity to come forward and say, this is what would have happened had we had that time, rather than to just say we would like to have investigated these things?
And certainly in our brief, we discussed the Robinson case where I think that it is talked about that there would be a proffer that appears to be an after-the-fact proffer. And we take issue with that case and that standard for several reasons. The first of which is that there is a fundamental time frame issue with when defense counsel is even able to present that proffer based on the investigation that they were not able to complete for the trial itself because of timing factors like here where the sentencing happened shortly after the conclusion of trial and the continuance was denied, so defense counsel wouldn't have that time. I think there's also fundamentally a problem with the Robinson standard because it's taking the good cause, which is reviewing the district court's decision at the time of the continuance hearing, and it is basically asking us to look at evidence after the fact of that ruling to then determine whether or not that ruling was reasonable, which is sort of asking for, it's not really reviewing the district court's decision at that point. It's reviewing something fundamentally different, and it's also putting this in, putting continuances for good cause under what is essentially a ineffective assistance of counsel standard. And this is not an ineffective assistance of counsel standard. This is not a case on habeas. This is a case that is being on direct appeal from trial court decisions, and this is trial error.
The problem with that is talented lawyers are always going to have questions that are unanswered as they walk into the courtroom to try a case. Always. And so why, if you claim this was error to push counsel to trial with these, let's just say there were a list of questions still unanswered, you don't have any obligation, you're saying you don't have any obligation after the fact to come in and show prejudice.
I am saying that we have asserted prejudice already at the continuance hearings, and that this court should be reviewing the evidence as proffered at the continuance hearings and the evidence that we are talking about that wasn't there. And beyond simply the evidence, in this case, we have other fundamental failures that the trial counsel was repeatedly alerting the district court to, including trial issues tied to, or issues tied to the ABA guidelines for capital cases that this court in the Cheatham case noted were helpful guidelines for determining deficiencies of counsel under a Strickland standard. And again, this is not an ineffective assistance of counsel case. This is a trial concern, a trial error that comes up in continuance hearings where counsel is alerting the district court to these deficiencies tied to the training and experience of counsel with guidelines 5.1 and 8.1, which included the fact that the second chair of this case, who is trying the guilt phase, had no previous capital experience and had never tried a homicide case before, that their mitigation specialist had no prior capital experience, that the defense team in this case was in its present configuration for 7 months prior to this trial, and that time to prepare, which I think is also notable to distinguish from the Robinson case, because in the Robinson case, we're talking about a team that went to trial that included 4 attorneys, 2 of which were experienced capital counsel, 1 investigator, and 6 interns who were on that case for 14 months before trial. Whereas this, we have basically less than half of the experience and the manpower working for half of the time here.
So are you saying that no reasonable judge would have pushed counsel to trial under those facts? I'm trying to get us to a yardstick.
Yes, that is what I am saying. That.
And what's your best case to demonstrate that you're right and that you are entitled to a reversal?
Well,
Best couple of cases.
I think one is Cheatham. And in Cheatham, while this is, again, not an ineffective assistance of counsel, this court started off talking about the ABA guidelines and deficiencies in counsel's performance. And one of those was simply the deficiencies in workload that counsel had, which are under the ABA standards 6.1 and 10.3, which are addressing both counsel's duty to have a workload that allows them to dedicate sufficient time, and the appointing agencies' duties to make sure that there is a workload that allows them sufficient time to perform effectively in capital cases. And in this case, starting off, we have defense counsel making a record of the fact that because they were required to bring in their workload from previous public defender offices when they switched to capital cases, that that Mr. Flack's case was less than a quarter or 30% of their caseload, that they were handling 30 to Mr. Frieden, when he came on, was handling 30 to 50 other felony cases. Ms. Wright was handling 30 to 35 other felony cases. And they are putting on the record that they have not had sufficient time, because of this other caseload, to focus on Mr. Flack's case at the time that they are requesting these continuances. We also have the record made about the massive and voluminous discovery in this case, which was at the time of the second continuance over 20,000 pages long, 500 discs, and 107 expert reports, including a significant collateral investigation. And at the third continuance, the defense counsel had continued to receive discovery, and they are putting on the record that they had not even completed the review of discovery in this case, let alone any investigation that would have to happen after review of the discovery. They stated that they understood this case, quote, in broad strokes at the time that they are going to trial. And we also have a significant concern with their lack of preparation, because as mentioned, there were other cases that defense counsel had unfortunately carried along with them that they were working on. Ms. Wright, for example, had a jury trial in another first-degree murder case that had been set for, I think, the first week of January, immediately prior to this case. So at the time of the third continuance, there were deficiencies counsel was recognizing, including that they had not prepared opening or closing statements at that point, that they had not prepared questions for cross-examination at that point, and that is in the context of a trial that was 2.5 weeks long, and and the state called over 120 witnesses, and they had not, at the time of the third continuance, prepared questions for cross-examination, where they had not reviewed the state's exhibits that were going to be presented or jury instructions, and had not even prepared for voir dire, which was already going on at that point.
What's the ability of the trial court to set deadlines? The first counsel was appointed nearly 3 years prior to trial. 3 years of time had passed since the charges were filed, counsel was appointed till the trial time. And in between those periods of time, I thought Judge Goddard's did a pretty good job of stating, here are the time frames, here's the expectations, and allowing you to proffer and to put forth evidence when those deadlines became somewhat apparent or close. And where did he go wrong? It just seems to me that deadlines were set, they were followed, and you were given plenty of notice of how much time you had, and you had, it seems to me, it's just hard when you're dealing with a context of 3 years, that within that time period, you didn't have enough time. So what happens here? What prevented you from prioritizing this case over other cases that you had, knowing that you had these deadlines?
Well, I think there are, of course, structural issues that defense counsel brought in all of these other cases as was part of their process, which is a fundamental issue here that was preventing them from being able to appropriately dedicate time. I think in the district court's rulings, one of the fundamental failings, again, is one, the sort of analysis that that said, you know, you've been on this case for X number of time. When this trial team had not been on that case for that number of time, that trial case, and Ms. Wright, who is having to handle the guilt phase, had been in that form for 7 months. There are also references repeatedly to this being an experienced defense team, when this was not a defense team that was experienced in capital cases, which require further investigation and preparing for 2 phases of trial and the preparation of a cohesive guilt and mitigation strategy, which did not happen here. So I think there are many points in there where looking at this case, both under the ABA guidelines for capital cases and the proffer that was shown, was that this was counsel that was unprepared for trial. And when you were looking at continuances for good cause, you have to look at the state defense counsel was at that time. And while other counsel had been on the case and could have had more time, this team was unprepared, and they're putting that on the record.
Counsel, how long had the defense team been aware of the tire tread evidence, for example?
I do not have a date for the tire tread evidence. They were, at the second continuance, talking about 107 reports that they had received that seemed in that same time period. I don't think the tire tread evidence had come up at the first continuance hearing. So
Mr. Evans aware of it?
I do not know from the record, or
Was it made available? I mean, it just seems like the way you're proffering this puts review, which is what we're trying to do, in an impossible situation to where we just have to surrender the timing of trial to whenever the appellate defender office stands up and says, well, now we're ready to go.
I don't think this court needs to surrender review of this. And in most cases, this, the good cause standard is a discretionary standard, and there's broad discretion in setting trial. This case is fundamentally different, both in scope of trial, time defense counsel had to prepare for this case, but also in the record defense counsel was making about their own effectiveness and their own preparation for trial at the continuance hearings. This wasn't simply them saying, I would like more time. This was them saying that there are fundamental failures in our preparation, that we need, that this would be a miscarriage of justice to go forward with this level of preparation. And of course, these were concerns that the district court also found were reasonable. There was voluminous discovery in this case. There were concerns, and ultimately and strangely, there was a continuance for 2 weeks granted because these concerns that were arising were real. They were not the fault of Mr. Flack. They were the district court did not find them even to be the defense counsel, like there are any delays there. This was a case where defense counsel did need time to prepare for trial, and that was wholly reasonable, and the denial of the requested continuance for 90 days to continue to prepare for trial and to finish the investigation in both the fact phase and the mitigation phase, which had not been completed, and defense counsel had not had time to thoroughly and thoughtfully and informed, or create a thoughtful and informed theory of mitigation in this case, where all of those failings were apparent on the record and at the repeated continuance hearings. I think that the district court's determination was unreasonable in this case, and that with all those factors in play, I ask that you find that the district court was unreasonable in denying defense's requested continuance that were necessary to prepare and provide Mr. Flack a thorough and meaningful defense, that it violated his constitutional rights to present a defense and his statutory rights to reasonable time to prepare. Turning to issue 2, I would emphasize that for Mr. Flack to receive relief on this issue, this court need not find that every reference to taking someone to jail is always an invocation of the right to end interrogation, because in the context of this case, when we get to the 6th, 7th, 8th, and 9th invocations, where Mr. Flack is responding to his continued questions with, take me to jail, take me to jail, take me to jail, he was clearly invoking his right to end interrogation, which a reasonable police officer under the circumstances would have understood. And
Counsel, do you know if the district judge ever looked at the video of the first interrogation before trial?
before trial? I do not. I could not find a reference to the district court looking at that video before, at the, say, suppression hearings. In my remarks today, I was going to point out that this video is in the record. It was Exhibit 4 in Volume 65 that the state admitted at trial and contains video of these invocations.
What, if any, importance would that have in our review?
Well, it is important in your review because it is, of course, this is a de novo standard because there's no dispute about the record of this. It provides additional context to all of these invocations that is serious and meaningful here. I am going to be referring to timestamps on that video throughout my discussion of these invocations here, which all occurred between 5:45 and 6:27 a.m. which was about 3 hours into interrogation, or between 2 and 3 hours into interrogation at that point.
There was a motion to disallow the statements at trial, but there was no specific motion to suppress filed on the basis of the right to silence or violation of the right to silence. To what extent does the absence of a motion to suppress or any findings of fact or conclusions of law on that specific issue impact our standard of review?
So I don't think it impacts the standard of review, because that is still a de novo review, where the everything before the court is in the same way. There isn't a dispute of evidence here. As to our preservation standards, we've argued in our brief both that this is a preserved under typical rules and preserved as to the capital rules. Particularly because before the district court, and objected to repeatedly throughout this, going as far as immediately before trial, defense counsel filed a motion objecting to the redacted interview under the suppression issue that was continuously renewed. The objections at trial were to the voluntariness and Miranda violations.
I don't think the question, though, goes to preservation. I think the question goes, or at least my question with that same point, is it doesn't matter, let me spout a little second. It doesn't matter what either one of the lawyers that are going to argue how they characterize what happened during that interview. It's on tape, it's not disputed. I know I've watched it 3 times.
Yes.
And I'm sure every other member of this court's watched. So it doesn't really matter how you want to describe it. What we have to get to is how to measure, what we saw. Not what you saw, what we saw. And so one of the questions is, how obvious was this supposed invocation? And when the defense doesn't make a motion during trial to say that the defendant's right to remain silent was violated, how is it so obvious now? See what my point is, you didn't make a motion during trial on the right to remain silent. It was all focused on the right to have counsel. So how is this fact pattern so obvious that even the defense missed it?
Well, I think that ties back into our issue 1, where defense counsel was already making, or was within their motions for continuance, noting that they had failed to file general motions, and almost all of their motions practice was responsive. So we're stuck in this strange situation where the state tried to bring this evidence in and sort of prompted where the issues that were being raised were with voluntariness and Miranda violations as to attorneys, and then defense counsel was acting responsively to that primarily. And so defense counsel, these did come up a little bit in there, and I think they were relevant before the district court in the context of voluntariness, as far as looking to whether Miranda violations have happened and how that impacts subsequent confessions. But I think these are just plainly obvious on the record. When the defendant is yelling, "Take me to jail, take me to jail, take me to jail," that is something that objectively reasonable officers would recognize as an invocation of these rights. And that's where I think this, the core of this issue and what this core is looking at, because it's not whether or not defense counsel was deficient at this point in failing to raise this issue, which would be a habeas review. It's whether or not the objectively reasonable officers looking at these statements would find them unequivocal invocations of his right to end interrogation, which they would. And starting even with the first invocation, which is happening at 5:45 a.m., Mr. Flack says, "So apparently we're at a stalemate, so do I put these back on and you take me somewhere, or what's the deal?" And this is, I think, important in this context, both and reminiscent of 2 cases, both the Aguirre case and People v. Villasenor, which was referenced in our 609 letter, where those are two cases where the defendants were invoking their rights to end interrogation, and they were talking about going home. In the Aguirre case, it's context relevant that he was talking about taking a child home, and in the Villasenor case, it's the defendant saying, just take me home. And those were unequivocal invocations of the right to end interrogation. In that context, partially because reasonable officers would understand take me home is a invocation of the right to leave the interrogation, to end the interrogation. And that's in the context of defendants who are not in custody and under arrest, or not under arrest. They at least thought they could go home.
So, again, this gets back to we can sit here all day and lawyers can characterize one way or the other on this. The U.S. Supreme Court standard is that this invocation must be unambiguous. Okay, what's your best case that what happened here was unambiguous? What case law do you rely on for us to look to that says, similar facts caused the court to believe a right had been invoked?
So there are several good cases here. Of course, there's the Walker case, which is from Kansas, that includes the statement, take me to a cell. That was an invocation. There is Johnson v. United States, which was in our brief, that include the statement, could you all take me to jail? I'm begging you, please. There is State v. Stroyer, which is in our 609 letter, where the defendant said, take me to jail for a second time and stood up. There is then other cases like Scott and Tanner, where the repeated invocations also meant this, or encouraged that this was unequivocal. And of course, I just mentioned People v. Villasenor, where just take me home was an unequivocal invocation. And in this context, of course, Mr. Flack is a defendant under arrest. So the difference between Villasenor and Mr. Flack's case is that he can't go home. The only place that he can go is to jail. And of course, as in this context, he is specifically discussing we're at a stalemate, meaning that this we can't go further anymore, and that he's asking, so do I put these on and you take me somewhere? Because putting in that context, obviously, that this ends by you putting the handcuffs back on me and taking me somewhere. And this is something that objectively reasonable officers would understand, particularly in the context of this case, because what do the officers or the interrogating detectives do at the end of this interrogation when they decide it is over? They put Mr. Flack in handcuffs and they transport him to jail.
Counsel, isn't there at least a potentially different way to understand the exchange of take me to jail or we're at a stalemate? I guess you can just take me to jail. It strikes me that at least one possible way to interpret that is the defendant saying, hey, you better change the way you're asking me questions or we're just not going to get anywhere. Is that a reasonable way to interpret this? And I guess the context I'm asking that is the clear and unambiguous way to end an interview is to say, I'm done talking. We're done here. I'm not talking anymore. But that doesn't happen here.
Well, I think there are two parts here. One, this is just the first invocation in a series of 9, and they are increasingly unequivocal to the point where he's responding to every question, take me to jail, take me to jail, take me to jail. And two, the rights here in the Miranda advisory aren't just talking about the ability to sit in silence while the interrogators continue to badger you with questions. It's a right to remain silent and end the interrogation, to stop the questioning. And that's in the Miranda rights advisory that he was even given in this case. So take me to jail, take me to jail, take me to jail is a statement of remove me from this room.
So you don't think there's any other plausible interpretation of those words? In other words, the communicative content of those words can't be anything other than end the interrogation?
Yes, by that point, yes. And I would obviously there are several different invocations here, right? The first one that we are discussing happens at 5:45 a.m. Then the remaining invocations are all happening between 6:10 and 6:20.
What about the last one, where he does it? Isn't there some point in which he actually, it is clear and unambiguous, where he says, I want to assert my right, whatever he says? Doesn't he ultimately do that at some point at the end? Doesn't the interrogation end with him actually invoking his rights, or am I wrong about that?
So the second interrogation ends at a point off of the transcript and off of the recordings where the officer said that he invoked his right to counsel.
Right, that's, look, it is, yeah, it's frustrating we don't have that transcript or a video of any of that, but apparently there was a point in which that happened. Is that right?
Yes, yes.
And does that make any difference that he knew how to do it, at least to the point where the officers recognized that this is a clear invocation of his rights and they ceased the interrogation, and what happened up to that point as being ambiguous?
No, Your Honor. Under the Smith v. Illinois standard cited in the Aguirre case and in the Walker case, we are not looking at post-invocation events and further statements as evidence as to whether or not the defendant invoked his rights at a particular time. And the fact that at a conclusion of interrogation, or that the state at some point, or sorry, the detectives at some point decided that he unequivocally invoked, does not change the analysis of whether objectively reasonable officers, when Mr. Flack was invoking his right to end interrogation, would have understood that. And
Doesn't it add context, though? And aren't we viewing the totality of the circumstances here? So why isn't that a relevant consideration amongst the other circumstances that are in play here?
well, one, because it provides very little context, because we don't have a transcript of it or video of it or audio of it. So we don't know what the magic words that made the detective say he invoked his right to an attorney was. So we can't, there's a limited ability certainly to factor that in. But more so because we're looking at his invocations at the time that were unequivocal. And I would emphasize that these were continuing, and particularly, of course, there were invocations 2 and 3 in here where he's talking about take me to jail, referring to the handcuffs, put these motherfuckers on me and take me where you need to do your fucking business. You know what? Put these on. And in both he is gesturing to his handcuffs at 6:10 a.m. in the morning. But there's also invocation 4, which is happening at 6:14 a.m. in the morning, where Detective Alexander is asking Mr. Flack, who the fuck do we talk to, Kyle? And Mr. Flack responds, I don't fucking know. You know what? Wrap these up, take me to fucking jail, because obviously you're just gonna keep going. So I can't give you information I don't fucking have, so do what you do. And at that point, there is a knock on the door in the interrogation room. And Detective Alexander gets up and leaves the interrogation room. Detective Mose stays in the room and with Mr. Flack. And they sit in the interrogation room for 3 to 4 minutes in silence, where there is no further questioning until Detective Alexander returns and reinitiates questioning. And I think that is also context that is indicative of the fact that Mr. Flack had just clearly invoked his right to remain silent as he sits 4 minutes in silence, and it is only that the detectives who did not scrupulously honor his invocation of that right are reinitiating the interrogation. And then,
can I ask you just maybe a step back on when we're doing substantial competent evidence review on this issue, right?
yes.
How does that work when we're noticing unassigned error? You know, typically we've got the district court findings, and then we're seeing whether they're supported by substantial competent evidence, and in turn whether the conclusions are legally sound based on those findings. Here, we don't have findings on this issue, but we also have the statute that allows us to notice unassigned error. What do we do? How do we do substantial competent evidence review in that circumstance?
Well, frankly, this court does not and is not doing substantial competent evidence review. This is an issue where there are no disputes as to fact. There's a transcript and a video, and this is de novo review.
Right, but there's no findings on this issue, right?
Yes.
So do we presume those findings were made and then just test them against the competing arguments then, or?
No, because again, this is an issue where there is no dispute in evidence. There's a transcript and there's a video and it is undisputed. And so this court is just looking at a de novo question with unlimited review and
Right, so we presume the district court found the statements were not an unambiguous invocation. And then we test that against the record and the case law.
yes, and of course, this court is ultimately looking at an objective question anyway, which is whether an objectively reasonable officer would have found these unequivocal invocations.
Counsel, isn't it true that we don't look at the judge's findings at all? Don't we make those findings as in a de novo review as a matter of law?
Absolutely, yes.
So turning to harmlessness then,
Yes.
what are the largest gaps in the circumstantial evidence supporting each of Flack's 3 homicide convictions? SW, AS, and then the combination of KB and LB, where the prejudicial impact of an erroneous admission of evidence might have affected the uncertainty in the state's case. And please address the capital conviction separately from the penalty phase, separately from the first degree murder and the second degree murder conviction.
Yes. And I will address those sort of chronologically here. With SW, the state's case was entirely based upon this confession that they obtained after these invocations were ignored. The state at closing argument is relying entirely on that. All timeline evidence and circumstantial evidence is weak. We are talking about a homicide that occurred in a time period where there are many people in and out of this house, and there is no more evidence connecting Mr. Flack to this killing than AS to this killing, for example. The entire narrative the state had was based upon the confession. As to AS, the state's case was also entirely circumstantial beyond the evidence they had in this confession. We are talking about a timeline that in itself is based upon circumstance and inference. We don't have any dates that we know specifically that this homicide happened. The state's sort of building these layers of timeline based upon inference about, say, cell phone communications, which involve AS's cell phone, which we don't even have circumstance, or is based upon inference of who is texting at particular times here, right? That the state has a theory that this homicide happened between the 28th and 30th. The only evidence that I think directly is that is the entomologist's evidence, which is problematic in and of itself because it didn't it only looked at basically the weather patterns outside, not inside. And of course, it conflicts with the state's timeline as to KB's death. But sort of the state's relying on what they can show, which is that after the fact, on May 3rd through the 6th, that Mr. Flack disposed of some of the evidence in this case, though not all of the evidence in this case, because I remind this court that there was the cell phone evidence at the John Brown Tower that showed AS's phone moving at that tower, receiving messages at a time that Mr. Flack was already in Emporia, and it had not been receiving messages at a time prior to that, so it had to have been moved or turned on in that area. So someone else is, it appears, is disposing of evidence, one of these unidentified third parties, so there are other people there as well. Excuse me. As to KB and LB, then, the evidence is also circumstantial and inferential, both to the timeline and anything beyond of Mr. Flack possibly disposing of evidence. And I would reemphasize again that when you're looking at sort of the physical evidence the state has here, right, we have weak exclusion rates for Mr. Flack and AS at this crime scene, but also in this evidence, the defense had there was unidentified third-party DNA intimately tied to this crime, right? There is evidence under KB's left and right hand fingernails that is DNA evidence that was coming from an unidentified third party that was not Mr. Flack, not AS, not SW. There is DNA, male YSTR DNA on the handkerchief that gagged her that is not attributable to Mr. Flack, AS, or SW. There is DNA evidence in her pubic combings that was not attributable, that is male YSTR DNA that was not attributable to Mr. Flack, AS, or SW. There is DNA on the forearm grip, the checkering of the murder weapon identified by the state that is not attributable to Mr. Flack, AS, SW, or any of the people who are identified as finding that weapon in the dump. So there's DNA, unidentified third-party DNA, tying someone else to this crime, at least to the extent that Mr. Flack is, and also evidence of a third party disposing of evidence, which is the evidence that the state had outside of this confession to tie Mr. Flack there. And then there is the tire tread evidence at the site where LB's body was found, which the state had identified and looked at and did not match the car that the state can put Mr. Flack is driving in. So again, evidence to a third party being involved in this case, and that the fundamental issue here is assigning whether or not Mr. Flack, the state cannot show whether or not Mr. Flack was a witness, an aider and abettor, or someone who just helped dispose of the evidence without this confession, putting him in the room, and ultimately tying him to this. Then turning to harmlessness on the penalty phase, I would note that the state has not briefed harmless error as to the penalty phase, and I think at this point has waived it. We have briefed harmlessness as to the penalty phase impact. And the first thing I'd point out is, of course, the state in its penalty phase opening and closing is repeatedly referring back to Mr. Flack's statements here. They are creating their entire narrative based on the narrative of ignoring in the statements that there was a third party and placing Mr. Flack in those roles. So just initially, that fundamentally impacted all of the mitigation and penalty phase arguments. The state's case was largely based upon that. The state, that also then impacted concerns of the jurors, right? These statements impact residual doubt. They placed Mr. Flack at the crime scene, which all the other evidence cannot do. It impacts things like their processing of remorse. And of course, while this mitigation case was flawed, as discussed in issue 1 and in our briefs, there was still significant mitigation in this case. Mr. Flack had a childhood that was permeated with physical abuse, sexual abuse, poverty, instability, and mental illness, a family history that, while limited because his paternal line is unknown, going back to issues all the way back to his childhood, that he was conceived from a sexual assault on his mother, so he never knew his father, and his family shamed his mother for having even birthed him. But there was a familial mental history that we already knew of mental illness, bipolar disorder, schizophrenia, and antisocial personality disorder. And Mr. Flack himself was diagnosed with major depressive disorder, bipolar affective disorder, schizoaffective disorder that impacted his behaviors, his repeated mental hospitalizations, his suicide attempts as a child, and going into hearing voices throughout his young adult life from this severe mental illness. So all of those factors play in with, again, I think the state has already waived harmlessness as to the penalty phase, but I think that this error cannot be harmless. I don't think it is harmless to the guilt phase findings for any of the homicides, and it is certainly not harmless as to the state cannot prove beyond a reasonable doubt that it is harmless to the penalty phase.
Going back to trial strategy, the state has suggested the possibility that you wanted to get this statement in so that you could get all this third-party information and allegations injected into the trial. Can you address that? Was it a strategy?
No, Your Honor, and I fundamentally do not understand where the state is coming from with this strategy angle, because one, going back to preservation, this is an issue that was repeatedly objected to, or not. The preservation analysis here is very, I think, slim as to the distinction here, where there was already Miranda violations objected to. There was already voluntariness objected to. And the voluntariness analysis, as you look at our last written objection to it in volume 5, page 2438, we're talking about voluntariness starting at the fact that Mr. Flack was handcuffed prior to the interrogation beginning. So there's not some piecing out of parts of this interrogation that defense was objecting to. There isn't anything of defense sneakily getting this in, as the state seems to be suggesting. Defense was repeatedly objecting to this. They fundamentally did not, or missed the invocation of his right to remain silent, but they are objecting to this. So the trial strategy angle ends there. But moreover, the entire implication that defense needed this evidence to present an unidentified third party is fundamentally flawed. Because again, as we go back to the DNA evidence in this case, there is DNA of an unidentified third party in the on the handkerchief that gagged KB, under her fingernails, in her pubic combings, and on the murder weapon. And there is evidence of someone else disposing of evidence in this case. So the defense did not need these statements to bring in the fact that there was an unidentified third party involved in this case, because the physical evidence is there. So for those reasons, and particularly the fact that by the 6th, 7th, 8th, and 9th invocations, where Mr. Flack is responding to continued questions with "take me to jail, take me to jail, take me to jail," he was clearly invoking his right to end interrogation, which an objectively reasonable officer under the circumstances would have understood. They would have understood it because of the context of this interview, where he had already discussed ending the interview by taking him to jail and putting the handcuffs on. But they would also understand it because when the detectives chose to end the interview, they handcuffed him and transported him to jail. So they understood how the interrogation ends. And for those reasons, we ask that you reverse Mr. Flack's homicide convictions and his sentence of death.
Questions from the court? Thank you, counsel. The court will be in recess until 10 minutes after the hour, 10:10.